the school did not ask her at that time what the meaning of her hairstyle was. Had the schooling wanted to know if she was engaging in political symbolic speech, they could have asked her if she was wearing her hairstyle for any particular reason. Had they done so, and had she at the time said, no, there is no reason for my hair, it's merely personal expression, then this case would be different. That's not how it turned out here. Now, whether Ms. Carter meets the two aspects of the Spence versus Washington two-factor test are of additional importance, since because she engaged in political symbolic speech, then she is entitled to very broad First Amendment protection. As was stated in Morse v. Frederick, quote, political speech is at the very core of what the First Amendment is designed to protect, unquote. Now, while Morse v. Frederick gave the schools broad authority to regulate students' speech and expression, specifically with relation to drugs, the concurring opinion of Justices Alito and Kennedy, who were two justices key to the 6-9 majority, places limits on how far Morse v. Frederick goes. They said, quote, it, meaning Morse v. Frederick, provides no support for any restriction of speech that can be plausibly interpreted as commenting on any political or social issue, unquote. Second, the district court did not use summary judgment appropriately. As the court stated in Score versus the Modern Door Corporation, when granting summary judgment, the court should consider evidence in the light most favorable to the non-moving party, which in this case would be Ms. Carter. Had the court done so, it should have assumed that Ms. Carter's hair had no drug connection, that her speech was political in nature, that it was therefore protected by the First Amendment, and that it was additionally not disruptive. What they did instead was take the word of her U.S. government teacher that her hair was disruptive. Although during the 2 years leading up to the incident, there were no other complaints from teachers or students. While opposing counsel states that 2 teachers came and complained to Ms. Blake, the principal, neither of these teachers considered Ms. Carter's hair enough of a disruption to actually take disciplinary action. As the court stated in Crucible...
But is that actually, I mean, is the existence of the disruption, the incident that led immediately to her expulsion, a disputed fact that the teacher whose responsibility is to maintain order in the classroom felt that the classroom was being disrupted? Why isn't that an issue that's basically resolved according to the teacher's view?
Yes, Your Honor. We do agree that the teacher does have the authority to call what is a disruption versus not a disruption in their classroom. And while Mr. Mansfield, the U.S. government teacher, may have felt that Ms. Carter's hair was disruptive, Ms. Carter was not the only party, nor indeed the initiating party in this disruption. The student sitting behind Ms. Carter, playing with Ms. Carter's hair, caused as much of the disruption, if not more. Now, had the teacher wished to regulate this disruption, which the teacher has full authority to do, he could have asked the student to stop playing with her hair. He could have separated the student and Ms. Carter. He could have asked Ms. Carter to keep her hair out of the hands of others. These are all perfectly legitimate steps and deal with the disruption in a way that does not trample on Ms. Carter's First Amendment rights. Furthermore, if we look at the 4th test in U.S. v. O'Brien, for when it is okay for the school to regulate a student's expression, it says that, quote, the school's regulation on First Amendment freedoms must be no greater than is essential to the furtherance of that interest, unquote. The school, in this case, took the route which most impinged on Ms. Carter's First Amendment rights.
But counsel, we're an appellate court, not a school board. So while much of what you're saying is a forceful argument, isn't it the role of this court to leave some of these judgments to school officials as to when it's disrupted and how best to deal with it?
Yes, Your Honor, that is correct. And as this court has stated before, the school must give broad authority to the courts must give broad authority to school officials, otherwise there's no way to enforce discipline. However, as the court stated in Freeman v. Flake, quote, although courts are reluctant to interfere with conflicts which arise in the operation of school systems, courts will interfere when such conflicts directly and sharply implicate basic constitutional values, unquote. In this case, when the basic constitutional values implicated are Ms. Carter's First Amendment rights, construed to mean any number of things, one could say the same thing about the Tinker armbands. That black armbands do not necessarily say, we protest the Vietnam War, nor in Spence versus Washington does an upside-down U.S. flag with a peace sign say, I oppose the Kent State shootings. In the same way, Ms. Carter's hair, while it does not directly state the purpose of the message, leads to conversation and leads to questions from those around her that will lead to her message being understood.
But isn't it that conversation and those discussions with those around her that the school finds to be the disruption or the potential disruption?
Your Honor, with all due respect, I believe that the specific instance of disruption in this case was not that the student behind Ms. Carter was attempting to talk to her about fiscal government spending before a U.S. government test, but that the student was attempting to play with her hair before a U.S. government test.
But if there were more discussion of what her message were in class or during school events, wouldn't the school be even more grounded in finding that to be disruptive?
Yes, Your Honor, to an extent, it would be if it substantially materially disrupted class. However, there is a very high ceiling for what counts as a disruption. If we look at Justice Black's dissenting opinion on Tinker versus Des Moines, he says, and I quote, there is also evidence that a teacher of mathematics had his lesson periodically wrecked, chiefly by disputes with Mary Beth Tinker, who wore her armband for demonstration, unquote. And while the court said that these black armbands were permissible because they were silent and passive and used to express views and influence opinions, the fact that they did cause some disruptions in class due to student discussion was not considered enough reason by the court at that time to regulate the students' armbands or to suppress their speech. Furthermore, Cruz v. Klunk states that statements about hair appearance are merely individual opinions, and the fact that this occurred so early in the school year, in September, just a few weeks after school had started, while Ms. Carter had been maintaining the same hairstyle for over 2 years, reflects that this instance of so-called disruption that Mr. Mansfield claims may merely be a personal aversion to green hair, and therefore does not represent a broad consensus. Broad consensus could truly only be established by a jury or a reasonable fact finder. If Ms. Carter's hair is not assumed to be disruptive, then even if Ms. Carter's speech is not constitutionally protected, the school still does not have the right to regulate it, since the dress code specifies non-disruptive hair color. Ms. Carter's hair meets the test Justice Fortas used in Tinker v. Des Moines for when student symbolic speech was appropriate in the school building. First, was it silent and passive? And second, was it used to express views and influence opinions? Ms. Carter's hair meets both of these tests just as much as Tinker v. Des Moines armbands did. Finally, if the school had any concerns about possible drug relations to Ms. Carter's hair, there were appropriate steps that they could take. The school did state in the meeting that they were aware that there were other students who had worn green hair and bling to demonstrate that they were drug dealers. As was stated in New Jersey v. TLO, if a school believes a student to be a drug dealer, if they have only a, quote, reasonable suspicion, unquote, there are certain steps that they can take. They can search the student's locker. They can search the student's possessions. They can search the student's body. They can do all of that without, as to go back to the fourth test of U.S. v. O'Brien, impeding on the student's First Amendment rights.
But counsel, under Morse and under general notions of giving discretion to school officials to maintain order and discipline, couldn't the school totally ban anything green from the school?
Your Honor, for clarification, are you asking if the school could ban all green things?
Yes. Any use of the color green anywhere in the building is prohibited. Wouldn't Morse give the school that discretion?
Your Honor, I believe that there are certain limits placed on Morse by the concurring opinion of Justices Alito and Kennedy, and that this must be dealt with on a case-by-case basis. If the student believes, or if the school believes a certain student to be a drug dealer, then they should take actions with regards to that certain student. Now, if the school had used the method that you suggested, and perhaps banned all quote-unquote bling, or all green hair, or all green hats or anything, then that would be a different matter, and there would be a different constitutional infringement that would be possible. However, we are not arguing that the dress code itself was unconstitutional. We are arguing that the way that it was implemented with regards to my client was unconstitutional. The effective ruling in the favor of the petitioner would be to place questions constitutional rights, which are differentiable from students with long hair who do not claim any political or constitutional protection. In conclusion, the court misused summary judgment because they did not consider evidence in the light most favorable to the non-moving party, in this case, Ms. Carter. And furthermore, summary judgment is not appropriate in this case because there are genuine issues of material fact which are up for interpretation, which would best be decided by a jury. For these reasons, Ms. Carter respectfully asks that the court affirm the Court of Appeals' reversal of the district court and remand for further proceedings to allow her case to be tried on the merits. Thank you, Your Honors.
Thank you. Mr. McNair, I guess 1 minute, 2 minutes.
Your Honors, in brief rebuttal of the counsel of the respondent, petitioners would like to raise a few additional responses. First, the record is dubious as to whether or not Ms. Carter actually conveyed her reported message to Ms. Lupo. Again, according to the record, this is simply hearsay. So, based on the facts of the record, which Farrell v. Dallas Independent School District states that we have to confine the facts to the record, it is clear and demonstrable that Ms. Carter has not communicated the message nor had an intent to. So, simply to clarify for this court the Ms. Jo Lupo issue, it was not conveyed necessarily to any student, the hairstyle.
Doesn't that argue against summary judgment when that was something that perhaps could be must have at the trial level, whether it was communication with or others?
No, Your Honor, because the district court correctly granted summary judgment in the fact that there was no genuine disputable facts. Now, according to Anderson v. Liberty Lobby, we are only to defer the facts and the evidence most favorable, or the light most favorable to the non-moving party, if there exists that genuine fact. And the district court essentially states, correctly so, that there's no substantive claim here. Ms. Carter simply making conclusory allegations, which again, according to Celotex, is clearly impermissible. Again, Your Honors, because the Tesla School District has demonstrated that there was a compelling governmental interest in regulating Ms. Carter's hairstyle, because it was notwithstanding not symbolic speech, the petitioners once more urge this court respectfully to overturn the holding of the Court of Appeals and reaffirm the granting of summary judgment of the district court. Thank you.
All rise. You may be seated. You may also call upon yourself.